Hey everyone, welcome to today's Explainer. If you've ever looked closely at the US immigration system, you know it's a massive, incredibly dense puzzle. But there's one specific piece, one checkpoint, that acts as the ultimate gatekeeper for national security. Section 212A3 of the Immigration and Nationality Act. Today, our goal is demystifying this exact section. We're going to decode the strict, highly specific legal grounds the US government uses to flat-out deny visas based on security threats.
Okay, let's dive into this. Here is our categorical roadmap for the law. We'll be breaking this complex text into 6 manageable buckets: security grounds, espionage and unlawful acts, terrorist activities, foreign policy, severe human rights violations, and finally, nuances, exceptions, and waivers.
Starting right off with Section 1, Security Grounds for Visas.
So the whole premise of the Immigration and Nationality Act is to set these firm, uncompromising boundaries to protect the U.S. from a huge spectrum of threats. And it's not just about who wants to cross the border. It's about evaluating what they might actually do once they arrive. To see how this plays out in the real world, you really have to look at the legal threshold. The law says a visa gets denied if a consular officer or the attorney general knows or has reasonable ground to believe an applicant is coming in to engage in unlawful activities. Now, reasonable ground to believe is the absolute cornerstone here. It's not beyond a reasonable doubt, like, what you'd see in a criminal trial. It's a very specific standard that gives tremendous discretion to consular officers stationed all over the globe. They are quite literally the first line of defense.
Moving on to Section 2, Espionage and Unlawful Activity.
That massive discretion we just talked about, it gets applied immediately in subparagraph A. This section targets your traditional state-level and operational threats. If we look at the specific text, the parameters are crystal clear. If someone is seeking to enter the U.S. to violate laws related to espionage or sabotage, they're out, period. But look at that second point, evading laws prohibiting the export of sensitive technology. I mean, think about how relevant that is today with cyber warfare and tech theft. It's huge. And naturally, anyone entering with the intention of opposing or violently overthrowing the U.S. government is stopped right there at the checkpoint. It's a hard boundary against operational attacks.
Next up is Section 3, Defining Terrorist Activities.
Now, terrorist activity is a term we hear all the time in the news, but legally speaking, it carries an incredible amount of weight. So what exactly counts as terrorist activity under the law? How does the U.S. legally quantify and pin down such a massive, heavy concept within its immigration framework?
Well, the INA actually provides a highly explicit list. Now, what's really interesting about this is how they define the severe parameters of physical violence directly in the text. It specifically names things like hijacking an aircraft or vessel, kidnapping someone to coerce a third party, violent attacks on internationally protected persons, assassinations, and using biological, chemical, or nuclear weapons, or even using firearms and explosives if the intent is to endanger safety or cause major property damage. It's basically a comprehensive catalog of extreme violence.
But here's the kicker. The law doesn't just stop at the person pulling the trigger or planting the bomb. It goes way beyond the main actor to define what it means to actually engage in terrorist activity. It includes inciting, preparing, or planning acts. It includes gathering target info. And this brilliantly illustrates just how deep that legal net goes. Take a look at that last point, providing material support. If you provide a safe house, transportation, false ID, or even transfer cash to an organization designated as a terrorist group, you are legally engaging in terrorist activity. And boom, you are entirely inadmissible.
All right, shifting gears to Section 4, Foreign Policy and Totalitarianism.
Now the law pivots from kinetic violence to politics and international relations. This exact quote from subparagraph C is absolutely vital. It grants the Secretary of State the power to deny entry if there's a reasonable ground to believe a person's entry would have potentially serious adverse foreign policy consequences for the United States. That is an incredibly broad amount of discretionary power. It essentially means that even if a visa applicant hasn't committed any crime whatsoever, if their mere presence in the U.S. messes with compelling foreign policy interests, the gates stay closed.
Subparagraph D continues that political focus by tackling totalitarianism head-on. The text explicitly and neutrally states that any immigrant who is or has been a member of or affiliated with the Communist Party or any other totalitarian party, whether domestic or foreign, is inadmissible. It's a fascinating, direct reflection of historical U.S. political and legal stances baked right into the immigration checkpoint.
There is a specific timeline attached to this, though. If the applicant's membership was with a party that actively controlled the government of a totalitarian dictatorship, the law says that membership or affiliation has to have been terminated at least 5 years before they apply, just to even be considered. Which brings us to Section 5, Severe Human Rights Violations.
Subparagraphs E and G zoom out to address some of the darkest global atrocities, ensuring that perpetrators don't find a safe haven in the U.S. It's a sobering, exhaustive list. The text explicitly bars anyone who participated in Nazi persecutions between 1933 and 1945. It categorically blocks anyone who ordered, incited, or participated in genocide, or who committed acts of torture or extrajudicial killings under the color of law. And it firmly denies entry to anyone who's engaged in the recruitment or use of child soldiers. These are the strict legal parameters translated to keep severe human rights violators firmly outside U.S. borders.
Let's move to our final bucket, Section 6, Nuances, Exceptions, and Waivers.
So the law isn't just one giant, rigid wall. It actually contains some highly specific conditional logic. Let's see how this builds. Look at the contrast in how the law treats families of individuals involved in terrorism. The primary offender? They face absolute, strict inadmissibility. But the law extends a nuanced protection to the spouse or child of that alien. If they can establish they didn't know and reasonably shouldn't have known about the terrorist activity, or if they've renounced it, they are actually exempt from that specific rule of inadmissibility.
We see a very similar nuanced logic when it comes to totalitarian party membership. Imagine a micro-narrative of someone living in a totalitarian state forced to join a party just to survive. The law actually accounts for that exact scenario. It explicitly provides exceptions if the membership was involuntary, if it happened when the applicant was under 16, or, and I find this highly specific phrasing fascinating, if it was solely for the purpose of obtaining employment, food rations, or other essentials of living.
Finally, we have to talk waivers. Section 212(d)(3) does provide a mechanism where the Attorney General can grant a temporary, non-immigrant visa despite certain inadmissibilities. So the crucial point here is this. While the legal system has a relief valve for temporary visits, it firmly, explicitly forbids waiving the most severe security threats. You absolutely cannot get a waiver if you're engaging in acts of espionage, trying to violently overthrow the government, or if you belong to specific terrorist organizations that target civilians. The perimeter holds firm for sure.
Which leaves us with this final thought. We've just mapped out the incredible complexity of INA 212A3. We've seen how it targets espionage, how meticulously it defines terrorism, and how it blocks perpetrators of global atrocities, all while carving out highly specific exemptions for unwitting family members or people just trying to survive under oppressive regimes. So how does a nation balance a strict legal security perimeter with necessary humanitarian exceptions? It's a constant, incredibly complex balancing act, and this text is the literal blueprint for how the United States attempts it every single day at embassies around the world. Thanks for joining this explainer. We'll see you next time.